England Take. I'm your host, AJ Kierstead. NewEnglandTake.com, that is a Substack and a great way to support the program. Got a whole bunch of new subscribers from the last couple of weeks because of my Concord Monitor reflection on the Concord Monitor's lack of being a good outlet to check out for the news. So be sure to check that out. Big thank you to Live Free Press. Actually pumped that out in their newsletter this week. Give a little extra love to another independent outlet. So this episode is sponsored by PorcupineCoffeeRoasting.com. Use code NETAKE for 15% off your order. Locally roasted right here in New Hampshire, specialty coffee. It's fantastic. It's what I drink every morning. She's been doing a little more on the Instagram. Give her a follow to see what she's got going on. PorcupineCoffeeRoasting.com. Use code NETAKE. All right, thank you WKXL also for picking up the program Saturdays 8:30 a.m. Concord AM Manchester, as well as Concord TV and GraniteGrock.com. This week, I am excited to be joined by Professor of Law, State Representative, Police Commissioner Buzz Scherr. Welcome back to the show.
I'm here to try and increase the number of people that listen to this show. It's my goal.
That you will definitely succeed because you are not part of my regular audience.
Think?
A slightly different political band, I'd say.
But I connect in many ways with your regular audience.
Yes,
as I do.
Yeah, definitely. It's people like to ignore the overlap, and something we'll talk about later on in the episode. Flock cameras. Definitely, there's that horseshoe loops really aggressively back around that other people have issues with that. So we will talk about that. But you initially reached out to me because of House Bill 1422. Right now, we are in a crazy time at the State House where Governor Ayotte is either signing or not signing bills. It's veto time, and she actually vetoed the most number of bills, I think, of any governor ever, if not the last 100 years at least, was the numbers I saw. So next Tuesday, or it's Tuesday, right? The 18th?
Wednesday.
Next Wednesday. The 18th is going to be veto day. So that is the day the House meets, and if 2/3 of the people that are there vote for it, it bypasses the veto. So it's going to be especially crazy, but you specifically want to talk about HB 1422. What is the basis of this?
The basis is pretty simple, although it gets technically somewhat complicated. But I'll try and simplify it. Right now, in New Hampshire, if you believe you are wrongfully convicted and in jail wrongfully, unless your claim was that a constitutional right was violated, you have only 3 years in which to file a motion for a new trial. So what that means is if 5 years from the time you were convicted, there is the scientific evidence that helped convict you turns out to have been fraud or wrong or a mistake was made, or if it turns out that you're just flat out innocent, and there's no DNA testing that's dealt with by a separate statute, you're SOL. You're out of luck because the New Hampshire statute says you can only bring a motion for a new trial within 3 years. It also, you can bring a habeas corpus petition after 3 years. There's no particular time limit on that. But in that petition, you need to allege a constitutional violation. So the fact that it turns out to have been bad scientific evidence that was used to convict you, or it turns out that the only witness against you comes up and said, I got to come clean. I lied about that. AJ never did that. You can't, if it's past the 3-year limit, you can't file a motion for a new trial. You're stuck. You're in jail for your whole sentence. Even though you've been wrongfully convicted. So HB 1422 changes that. It says the 3-year limit still exists unless you have newly discovered evidence that didn't exist at the time you had your trial, or that there was new scientific testing that didn't exist at the time of your trial, or the scientific evidence used at trial has been turned out not to be good science. If you meet one of those three things, you can file a motion for a new trial after the 3-year period. So it's I've been working for several years with the National Innocence Project, for that matter, the New England Innocence Project on this. And this year, after working closely with Representative Lynn in the House uh, and others, this bill, HB 1422, passed the House on the consent calendar, and it passed the Senate on the consent calendar. And then the governor vetoed it. I think the governor probably got bad advice from somebody. Her veto message suggests that, well, you can file a habeas corpus petition, or you can file what's called a coram nobis petition. Um, and so those are still available now for the circumstances described in 1422. That's just not true. Somebody told her wrong. You have to have a constitutional violation to file a habeas corpus petition.
Which is a very different thing. I make that very clear
Yeah,
to people. That is extremely different than having an evidence situation that could very likely prove your innocence.
yeah, but it has nothing to do with a constitutional, classic constitutional motion for a new trial on a constitutional basis is ineffective assistance of counsel. You have a constitutional right under the Sixth Amendment to effective assistance of counsel. That's a classic habeas corpus petition for even after the 3-year deadline. And coram nobis has the same requirement of a constitutional violation. It's used when the person who's filing it is no longer incarcerated. That's the difference between a habeas corpus petition and coram nobis. But so somebody gave the governor bad advice.
Yeah, and this is totally nonpartisan when it comes to the people. The sponsors of the bill are fascinating.
Isn't it though?
Representative Tom Mannion, who I've had on the show before, defend the guard guy. I love him a lot.
He's slightly to the right of me.
Yeah, just a little. Representative Corcoran. What? That must have been interesting.
Yeah. Yeah, well, it really is. Innocence Project stuff is nonpartisan or bipartisan, whatever the right word is. It's just we don't want people in jail who are innocent, and we want to give them a chance to prove that they're innocent. There are some requirements in 1422. You can't just say I'm innocent, I want a hearing, and you get a hearing. You got to make a certain kind of showing that the judge screens before he grants a hearing. Once he grants a hearing, you get a right to counsel. And because, most people in the state prison don't even know how to file these things.
Right.
And so, as long as you make a good faith effort to file something that looks like it might be a problem, and the judge recognizes that, he'll grant you a hearing, give you a lawyer, and then you need to the burden is on you to make a showing that what you say is the case was the case. And so it's not as if you're going to have a flood of these petitions filed.
Right.
Ever since we changed the forensic DNA or post-conviction DNA statute several years ago, people who objected to it were saying, no, you can't do this. You're just going to get a flood of petitions. There hasn't been a flood of petitions, and because I'll get really to the core of this, because the criminal justice system is imperfect, and we know it's imperfect. You just need to go to the National Innocence Project's website to see that mistakes are made. Sometimes intentionally, sometimes not intentionally. So you can't have a system that processes so many cases work perfectly in every instance. And the nightmare of any defense lawyer and the nightmare of any good prosecutor is that an innocent person is convicted, in spite of the efforts you make, and it happens, we want to give people in that situation who can make just a prima facie showing, a superficial showing that they may have been wrongfully convicted. Let's give them a hearing and give them a shot at it. There's no great administrative or other cost to it. And the thought that there are people in jail wrongfully convicted, should keep people who are involved in the system awake at night.
Yeah,
You know?
I mean, there's the reason why we have the jury system and all these. We've had all these expansions of technology and DNA and things like that over the last 50 plus years, is to make sure that that's prevented by any means necessary. And the fact
Exactly. And
that,
we've learned,
yeah,
we now can document. The Innocence Project has been around for 30 plus years now. So we can document real wrongful convictions, people who come off death row who were wrongfully convicted, people who have been incarcerated for 30 or 40 years, turns out they're wrongfully convicted. What's interesting is we're seeing more and more cases not involving forensic DNA evidence. I mean, those are neat and tidy, but more and more cases involving bad science,
yeah,
like hair and fiber analysis, that it turns out wasn't as great as it was offered up to be when it first came in. Shaken baby syndrome there's been a lot of questions about that recently. And it happens, it's just life is not perfect, science is not perfect, and we need to have a safety valve.
definitely.
It's really important. And I think whatever happened, 1422 takes care of that. Whatever happened with the governor, I think she just got bad advice from
Yeah.
somebody.
And I'll put a link in the episode description or on the site at nhtalkradio.com with HB1422's language. Once again, Buzz Scherr is a Democrat. Representative Lynn, who you mentioned previously, is a Republican who's a former New Hampshire Supreme Court justice. This is a bipartisan. People are saying, hey, we need to make this happen. So we're trying to raise awareness to that. So spread this episode around, especially when it comes to this, because we want to make sure that this gets a proper chance for veto day on Wednesday the 18th.
And if you're, if you're interested in what I said, I highly recommend going to the National Innocence Project website. It's very, very informative, and it's scary.
Yeah. All right, let's shift gears. Let's go in another direction here. You were the first person I thought of when I saw flock cameras have all sorts of things.
Life, right?
Exactly. So we've talked. I previously hosted the Legal Impact over at UNH Franklin Pierce School of Law. Loved that episode, that show, and we did all sorts of episodes around facial recognition and CCTV TV cameras, things of that nature, and flock is the big giant in the room when it comes to data privacy out in public in the United States. And it's one of those things it's always been this kind of dystopian thing to me, hearing the stories of like London, England, and all the cameras they have everywhere. And I'm like, you're catching people, but wait a second, where's all this data going? And in this situation, guess what? It's being fed into it's some AI algorithm and could be utilized for, I don't know, stalking by police officers using it incorrectly.
It's the ugly mix of facial recognition, AI, and cameras. And I've done a good bit of writing in the area of how much privacy do we give up when we're in public, and that's a piece of this. The interesting thing with Flock, which it's the name of a company, they have fixed cameras that read license plates. That's basically what they do. And then they store the license plates. And the camera can be fixed outside your home, outside the state office buildings, on every street. It's up to the police department who gets into business with Flock where they put the cameras to read license plates. So they are a newer form of what have been around for a while, license plate readers. What's interesting in New Hampshire is 10 years ago, then Representative Neil Kirk, one of the great privacy advocates in the last 20, 30 years in New Hampshire, conservative Republican, but very much a privacy advocate. He sponsored and got passed a bill. I don't have the statutory site right now, but it's a license plate reader bill. And it says it takes care of, we're one of the few we're one of the few states that has already in place a license plate reader bill, where you can only do certain things. You can only keep the data you get from it for 3 minutes, then you get rid of it unless an arrest has developed from it. We already have a good statute in place. This past session that is just ending, past legislative session that's just ending, the 25-26 session, the bill that Representative Kirk got passed had a sunset provision.
Oh.
It was sunset in 10 years, in 2026, December 31st, 2026. I was the prime sponsor of a bill last session that repealed the sunset provision, so made it permanent, and it got passed, and the governor signed it.
Awesome.
So we have a license plate reader bill. What Flock is going to be doing is they're going to go to they're already, as I hear through the rumor mill, they're already going to police departments and said, oh, this is even, this will be better. You can have these fixed cameras. It's not just at toll booths or other places. You can put them all over the place. This is great. You're going to make the public safer. And that's the sell that they're going to, and I anticipate that they're going to, somebody is going to file legislation to make it easier to have flock cameras around. Right now, you can't. Portsmouth Police Department doesn't use them. I know, because I'm chair of the police commission, and there's no instinct to use them. They're fine with, and the Police Chiefs Association, when I ended up not opposing my effort to repeal the sunset of the LPR statute. So we're well positioned in New Hampshire, but I think the bigger concern that I think you mentioned at the beginning is this is just the start. Well, of cameras everywhere. Well, we got lights right here. Why don't we have just regular cameras everywhere, like in England?
Yeah.
And the other thing that's at play here is Part 1, Article 2B of the New Hampshire Constitution, which says an individual has an individual's right to live free from governmental intrusion on their personal or private information is inherent, essential, and I forgot what the last word is.
You only wrote it.
I wrote it, and I can't even remember. It shows how old I am. But that's been in place from 2018, and it raises the question: is your face in public? Can the government capture that, and are they taking away personal or private information, even though it's in public? That's an interesting question. There's a U.S. Supreme Court case that says U.S. v. Jones, or Jones versus U.S., that says that the case was that the police in D.C. suspected Jones of being a major drug dealer. They wanted to put a GPS on the bottom of his SUV and follow him around for 10 days to see all the places he went. So he, who is he selling to, kind of thing. They thought about getting a search warrant.
That was the mistake there. Kind of a big mistake.
It's even worse. They got a search warrant to put it on the bottom of his car and follow him around because they were concerned that it might violate the Fourth Amendment. But the search warrant only was good for 10 days. They didn't put it on the SUV until day 11 or day 12.
Jeez.
So when Jones got arrested based on some of the information that was collected, his defense lawyer said, "Hey, you needed a search warrant. And you didn't have one. It's a violation. It counts as a search. And you need a search warrant because it counted as a search." So the issue in the U.S. Supreme Court was putting a GPS tracker on the bottom of his car when it was parked in a public place, did that count as a search that got him Fourth Amendment protection? And the U.S. Supreme Court said, yes, it did count as a search. Even though arguably every place he went was public information, you know?
Yeah.
So,
And that's a perfect parallel for Flock. I mean, that's the whole nature of how it's been utilized in a lot of the PR that Flock has put out around this, and the police departments in other parts of the country that are in support of it. They go, well, if we have someone who was kidnapped, we're able to say they went this place, this place, this place, as opposed to thinking about the greater constitutional impact of just universally just collecting everything and like, is this the way we should be doing it? Is it the right thing? The right thing is not always the easy thing. It's not always the thing that's going to make everyone safer.
and what we've done with the LPR statute is we've regulated what police can do. We haven't said, in no way can you ever use these license plate readers. We've just put some boundaries on it, which is what going forward as we sort through all these really difficult privacy questions in the 21st century with public information, private information, what's the difference, where information is really what the 21st century is about in privacy terms, far less than and far more than what it used to be about in the 20th century was cars and homes and buildings and your body. Now it's all about information and how much of that is private. So, what we need to do going forward, we need to have some principles laid down, like we do in our constitutional amendment, and then through statute, we need to kind of regulate. Okay, if we regulate it this way and this carefully, that'll pass muster constitutionally, and it won't concern us as much in terms of invasion on our privacy. Yet we'll still be able to use it for police investigation.
Yeah, and it's something people should consider also in the private sector separate. I believe it was Representative Alice Wade actually had a post on Facebook that I saw earlier where one of the hospitals in her area put up a flock camera to track just for security for monitoring traffic, and it was brought up to the city council, and the hospital decided to take it down because of the complaints that they had. Like, these cameras are being used on the private side too, and you got to consider, do you want these in your neighborhood? I'll link in the episode description a video by Internet Esquire. He's a conservative lawyer who he actually, as he was working on the video, he discovered he actually had a flock camera that was installed at the end of his driveway by his municipality, and he's like, now I gotta go to city council. I don't want to do that.
Well, what I'm hearing people I've talked to are outraged by it. I've there's a city councilor in Portsmouth who really I think he now understands that we're in pretty good shape here in New Hampshire, but he's talked to a number of constituents, SFI in Portsmouth, who want no part of these flock cameras. It's just, and appreciate something that sometimes gets lost in this when the police say, "Oh, we need this," criminals are out there, we need to be safe. Well, New Hampshire is either the first or the second safest
Yeah.
state in the country. It has the lowest homicide rate in the country. It was even the first or second safest state in the country during what our governor thinks about as the failed social experiment called bail reform. The crime rate in New Hampshire kept going down during bail reform. The number of violent crimes, the property crimes, the last year of the governor's term as Attorney General was 28,000 plus. Well, in the last year of bail reform, or in 2023, 2024, the number of violent crimes and property crimes, while bail reform was in effect, was 13,000. So it's way too easy to scare the public, saying we got to be safe, we got to be safe. Criminals are out to get you. When we're already doing a good job in New Hampshire. We've been doing that for years. And we've got to be as more conscious of our privacy concerns than we have been. And so this fits into that narrative.
100%. All right, so we got the last 5 minutes here. I want to have you talk about you are running for re-election. Is that right?
I am.
What's your grand plan?
Unopposed.
What's wrong with these people in
Or in the
Portsmouth?
general election.
What's wrong with these people? Oh, it's Portsmouth. You're not getting a Republican voter out there. So
Portsmouth is a somewhat democratic city.
just a little. I'm always surprised looking at the geography of the representatives when I look around Nashua because of how extreme left so much of Nashua is, and then you start like, oh, it went the total other direction immediately out of nowhere. Portsmouth, you're pretty safe.
Yeah, Dover too.
Yeah. Oh yeah. Any grand plans here for the next term that you're thinking about?
Yeah, I'm going to put forward a bill that that says if a federal official has violated your constitutional rights, state constitutional rights, or federal constitutional rights, you can sue them in New Hampshire court for damages.
Interesting.
That is currently not the case. And I think this is a attractive as a bipartisan matter. Some people think about immigration and the abuses of ICE. Some people think about ATF and their abuses. And I think this is one of those bills that I'm starting to talk to people that cuts across the partisan boundaries, and it allows states to hold the federal government accountable in a way that doesn't really exist in a practical way right now. And you go back to the founders, their goal was to have a lot of checks and balances. And one of the checks on the states was the federal government passing laws and preempting conduct on the part of the states. But it's been the states, until recently, the states have not really been active in finding ways to do what the feds can do. That is, if federal officials misbehave in a unconstitutional way, they can be brought into state court. The federal officials, if you are acting outside the bounds of the Constitution, state or federal, we can hold you accountable in state court. And there's Illinois passed a bill. Maine has language in its statutes that is similar to this. California has some language. It's not quite on point. So yeah, I'm working on drafting that, and I think I'm going to be able to recruit Republicans and Democrats. Hopefully, we'll have the same kind of interesting mix of people as co-sponsors on that bill that we did on 1422.
Yeah, I mean, it totally aligns. I mean, make no mistake, anyone out there listening, us libertarian-leaning individuals, not a big fan of the feds, so any way we can keep them in line is bipartisan once again.
Another thing I'm going to do is bring back yet again a bill I've been putting forward for 2 years now to make mandatory the recording of custodial interrogations.
It's not?
No.
Wow.
Most police departments do it, but it's not mandatory. And there's some reasonable exceptions to it. If your machine breaks down or, one thing or another, you can, there's some reasonable exceptions. But, one of the things we know from the Innocence Project data, somewhere around between 25 and 30% of all wrongful convictions, at least based on a study of their first 200 wrongful convictions, 25 to 30% of them, the person either pled guilty or confessed to a crime they didn't commit. And what you see there is vulnerable people being intimidated by the police. Young people, people who English is their second or third language, people with intellectual disabilities. So we've been getting through the House easily. We're still bumping up against the Senate.
All right. Well, I'm very excited to hear about these two bills and what's next for them. It's been awesome. Professor of Law Buzz Scherr, State Representative, Portsmouth Police Commissioner. Thanks so much for joining me today.
Wonderful being here. Thank you, AJ.
NewEnglandTake.com to subscribe to the Substack. Thank you to WKXL, the Granite Grot, Conquer TV, all these amazing local outlets for supporting the show. We'll talk to you soon.